6:47 a.m., received legal notification from my attorney. The message stated she had engaged her third law firm, implying a scorched earth approach. Contact me before discussing the matter further with anyone. Standing in my kitchen, I was mid-sip of coffee when confusion struck over the term third firm. My soon-to-be ex-wife, Cassandra, had already cycled through 2 legal teams in 6 months. 2 retainer checks worth $45,000 to Morrison and Associates, followed by $38,000 to the Bergman Group, had cleared our shared account meant for household expenses. Both firms abandoned her case within weeks, and now a third had joined the fray. Reached out to my long-term attorney, Anthony, who's managed my business contracts, real estate transactions, and this recent dissolution of a 10-year marriage due to a sudden unfairness in our prenup. Kay Zolano is representing Cassandra now, Anthony informed me, his voice devoid of emotion, signaling bad news. This law firm specializes in handling complex divorces of high-net-worth individuals. They only accept cases where they believe they can win. The prenuptial agreement is solid. You drafted it yourself. I acknowledged. What troubles me is its origin. Kay Zolano wouldn't represent her unless they found something suspect. As events unfolded over the next 8 months, I realized it was desperation disguised as a strategy. Let me elaborate. Cassandra and I crossed paths when I was 31 and she was 28. I had recently sold my first software company for $8 million. She was a talented project manager at a marketing firm with a trust fund from her grandmother that provided around $60,000 annually. We fell in love quickly, moving from our first date to an engagement within 6 months. My lawyer strongly recommended a prenuptial agreement. It wasn't because I didn't trust Cassandra, but because I had witnessed my business partner go through a costly divorce that split his company in half. The prenuptial agreement clearly stated that assets accrued prior to marriage remained separate, while those acquired during would be equitably divided based on contributions. Both parties waived spousal support. Cassandra's attorney had reviewed it, and she signed it 3 weeks before our wedding without any objections. For 9 years, we seemed content, though in retrospect, I believe this was not the case. It was a Tuesday evening in February when her phone kept vibrating on the kitchen counter while she was showering. Out of habit, I looked at the screen and read a text from PT. "I can't wait to have you all to myself. He'll never give you what you truly deserve." I recognized the sender as Pierce Thornton, my ex-business partner, who had been present at our wedding and dined at our house monthly for years. Without directly addressing her, I engaged a private investigator named Gloria Chan instead. Gloria charged $400 per hour and was worth every penny. In 3 weeks, she obtained photographs of Cassandra and Pierce meeting at various hotels, restaurants around town, his apartment. She had credit card receipts indicating Pierce covered expenses like jewelry, clothes, weekend trips that Cassandra claimed were work conferences. The affair lasted 14 months before I filed for divorce on March 15th. I asked for nothing beyond what the prenup outlined since I had $12 million in assets at the time, which included the original sale money and its growth, as well as my company valued around $8 million. Cassandra had her trust fund, salary, and approximately $200,000 from her grandmother's estate in a separate account. The prenup stipulated she would receive half of our shared home equity, around $180,000, with everything else remaining separate. There was no spousal support, and the split was clean. However, the first lawyer Cassandra hired, Morrison and Associates, attempted to argue that the prenup was signed under duress. In response to allegations of presenting the prenuptial agreement too close to Cassandra's wedding, causing pressure, Anthony provided emails demonstrating that Cassandra's own lawyer had reviewed the prenup for 2 weeks. Cassandra suggested a modification herself, and she signed it 3 weeks prior. This fell within legal standards, prompting Morrison's withdrawal from the case. Bergman Group then attempted a different approach, claiming hidden assets during the marriage, that the current company was started with marital funds, thus entitling her to half its value. However, this was inventive but incorrect. The company was started with a $2 million investment from separate premarital funds, backed by documents tracing each dollar's origin. Depositions showed Bergman had no evidence, leading to their withdrawal. Kay Zolano then took over the case. Then Cassandra's tactics changed from legal finesse to open combat. The initial clue was the private detective trailing me. I spotted him on a Thursday, a man in a gray sedan parked opposite my office, later behind me at the supermarket, and eventually patrolling my street at night. Upon Gloria running his plates, I discovered he was Dominic Russo, a licensed investigator contracted privately to Casolano's law firm. They were searching for anything: an affair, secret finances, dubious business transactions, drug use, essentially anything they could exploit to undermine my character or the prenuptial agreement's validity. I inadvertently made their task simpler. I went to work. I visited the gym. I had dinner with my parents every Sunday. I attended therapy on Tuesday evenings. I led a life as transparent and documented as possible, while Cassandra was spending lavishly, as if attempting to break a record for expenditure. Her Casolano retainer amounted to $75,000. She proved payment from her inheritance account and later provided bank statements as evidence. Subsequently, there was Russo's investigation leading to another $28,000 over 3 months. Later, she employed a forensic accountant named Hilton Crawford to scrutinize all my business records and uncover hidden assets, with his fee amounting to $45,000. Anthony kept track of the expenses. At that point in our divorce proceedings, Cassandra had expended $183,000 trying to circumvent a prenuptial agreement providing her a straightforward $180,000 settlement. During one of our planning sessions, Anthony commented, "She's going to deplete herself." At the time you filed, she possessed $200,000 in liquid assets. "She's squandering it," he said. "Can't her lawyer notice this?" I asked. "I assume they can, but she's the client. If she wishes to continue fighting, they will keep charging fees." The absurdity wasn't lost on me. Cassandra was using up her entire inheritance, money that her grandmother had bequeathed her, in an attempt to gain access to my premarital funds. The money was never meant for her according to our agreement, but in month 7, Cassandra initiated a gossip campaign within our social circle. She spread rumors that I emotionally abused her during our marriage, controlled her finances, and coerced her into signing the prenup by threats. She presented this false evidence to 3 different couples we were friends with. The text messages, she claimed, demonstrated my manipulative and cruel behavior. However, 2 of those couples contacted me after seeing the texts. They found the conversations suspicious, filled with screenshots of supposed arguments where I allegedly called her stupid and threatened to abandon her with nothing if she didn't obey me. In reality, these messages were fabricated as I admitted to them. They verified the metadata and phone numbers, confirming that the texts were not authentic, likely crafted by an app or perhaps Cassandra herself. The number she asserted as mine had a single-digit discrepancy, marking her transition from desperate to potentially threatening. Anthony submitted court documents detailing the fabricated proof and slander. These documents included affidavits from friends she'd contacted and digital forensics analysis confirming the bogus messages. Additionally, they presented a timeline outlining Cassandra's increasing aggressive actions. The judge arranged an immediate hearing. During this hearing, Cassandra's attorney, Veronica Hart of Casolano, attempted to retract the falsified texts. She alleged that Cassandra was confused and had misunderstood messaging app operations, with no malicious intent. However, Judge Patricia Holcomb, a 62-year-old judge with 3 decades on the bench, showed disapproval. Ms. Hart, Judge Holcomb stated, her voice echoing the gravity of her years in court, was not convincing. During ongoing divorce proceedings, your client submitted fake evidence to harm the petitioner's reputation. A state of confusion is not a justification. What is your client's stance on this matter? Cassandra, seated beside her lawyer, remained silent. Hart, addressing the judge, explained that his client is experiencing intense emotional turmoil. As she was prepared to acknowledge the messages were fabricated and halt all out-of-court discussions regarding this case, a prolonged pause occurred, followed by Cassandra whispering something to Hart. Yes, Hart confirmed to the judge, a restraining order had been issued, prohibiting Cassandra from discussing the case with anyone except her legal team. Hart then shifted focus to the central issue. Judge Holcomb stated that he had scrutinized the prenuptial agreement and both parties' motions. Ms. Hart, on what grounds does your client challenge this agreement's legitimacy? This was the crux of the matter. At the point when 8 months and approximately $250,000 of Cassandra's funds had accumulated, Hart rose to speak. Your Honor, we contend that the prenuptial agreement was obtained through deceit and duress. The defendant presented the agreement 3 weeks prior to the wedding when deposits were non-refundable, and guests had already made travel arrangements. Our client felt she had no option but to sign to avoid public embarrassment. Furthermore, we found proof that the plaintiff undervalued his assets at the time of signing, making the agreement substantially false. Anthony stepped forward before Cassandra had finished. Your Honor, may I reply? Of course. The defendant's own attorney reviewed the prenup for 14 days. The defendant herself proposed modifications that were included. We signed the agreement 3 weeks and 2 days before the wedding, well within the legal standard. Regarding asset valuation, we provide records detailing all assets owned by the petitioner at that time, appraised independently and certified by an appraiser chosen by respondent's counsel. If Ms. Hart has proof of fraud, we ask to see it. Hart handed a folder to the bailiff, who passed it to the judge. Judge Halcombe, this is a report from our forensic accountant highlighting inconsistencies between the petitioner's reported assets in 2014 and his actual possessions. The judge perused the documents. I observed her expression. She appeared unimpressed. Ms. Hart, the judge said slowly, this analysis demonstrates an increase in Mr. Brennan's company valuation between the date of the prenup signing and the wedding ceremony. That's growth, not fraud. Unless you're suggesting that Mr. Brennan should have foreseen his company's value 2 weeks into the future. Judge Halcombe, the size of the increase implies. This implies his company had a productive month. This is not evidence of fraud. Are there any other matters? Hart appeared thoughtful. He looked at Cassandra, who was fixed on the table. Your Honor, we ask for a delay to collect more proof. Denied. This case has lasted 8 months. You've had plenty of time to show proof of fraud or duress. I'm maintaining that the prenuptial agreement is valid and enforceable. The asset distribution will follow the plan in that document. We will reconvene in 30 days for final settlement. The gavel sounded. Outside the courtroom, I saw Cassandra crying while Hart spoke quietly to her. I didn't approach them. I didn't feel. I feel victorious but tired, Anthony told me. Castellano will abandon this now that the prenup is upheld. She spent everything contesting it. They obtained Gloria's recent financial records through legal discovery. She has approximately $11,000 left in her accounts. Her trust fund doesn't disperse until the upcoming quarter. She expended $189,000 on legal expenses, investigators, and forensic accountants. A settlement worth $180,000 would have been detrimental with this expense. She spent more on contesting the prenuptial agreement than she would have received by accepting it. However, Cassandra wasn't finished. A year later, I received a call from Pierce, my previous business partner, the man with whom Cassandra had been having an affair for over a year. We need to talk, he said. We met at a downtown coffee shop. He appeared tired and older than his 41 years. She's asking me for money, Pierce stated without hesitation. For her legal fees, she claims you've blocked her access. She states she has no funds left. I didn't block anything. She used up her inheritance trying to invalidate our prenuptial agreement. I am aware. He rubbed his face. Listen, I'm not proud of my actions. The affair was wrong, but she's in a downward spiral. She discussed overturning the judge's ruling on employing another law firm. I inquired, are you going to give her the money? No, Pierce replied after a lengthy pause. I can't. My wife discovered my infidelity. We're parting ways. I'm preoccupied with my own divorce now. Frankly, Cassandra unnerves me. This entire situation, the fabricated messages, the investigation, her fixation on your funds, it's no longer rational. He left a $20 tip for his coffee and departed. I sat pondering over the woman I had married. The intelligent, ambitious project manager who made me laugh on our initial date, who wept tears of joy when I proposed, who pledged to construct a life with me. Over time, that woman seemed to vanish, leaving behind someone I scarcely knew. A person prepared to forge proof, squander her inheritance, and jeopardize her own financial stability out of spite for me, due to my decision to safeguard assets I had already earned before our relationship began. The divorce settlement hearing took place on November 3rd, 11 months after the divorce filing. Cassandra arrived without legal representation, as predicted by Anthony. Castellano had deserted her. She attempted to find another law firm but was unsuccessful due to the legal community's awareness of the upheld prenup and the client's depleted funds. Mr. Holcomb scrutinized the settlement conditions. Miss Brennan, you will receive $182,000 as your portion of the marital home equity. The remaining assets will remain separate as outlined in your prenuptial agreement. Do you comprehend these terms? Cassandra spoke quietly. Yes. Do you have any objections to these terms? No, Your Honor. The judge ratified the order. Your divorce is finalized. Best wishes to both of you. In the corridor, I spotted Cassandra standing alone. She seemed smaller, less imposing. I considered approaching her, saying something indeterminate, a gesture acknowledging the decade we'd shared before everything disintegrated, but Anthony placed a hand on my shoulder. Don't, he whispered. She chose her path. You did too, let it rest here. So I departed, 3 months passed, and Gloria phoned me with news. She'd kept in touch with some of her contacts from the investigation. Cassandra secured a job in Oregon, Gloria informed me. A smaller city, lower living costs. She manages projects for a nonprofit there. Pierce's divorce was finalized. His ex-wife got the house and half his share in our old company. He resides in a downtown rental. Good for her, I replied, referring to Pierce's ex-wife. There's one more detail, Gloria added. I discovered the total amount Cassandra spent. Through legal fees, a forensic accountant, and filing costs, she ended up spending $198,000 to challenge the prenuptial agreement. This amount exceeded what she would have received from it by $16,000. Besides money, she lost a year of her life, her social circle, and any remnants of a relationship with Pierce. All this was for trying to nullify an agreement she had signed voluntarily a decade ago. I ended the call in my office, overlooking the city. My business was thriving, my new relationship was progressing under my therapist's advice, my parents were healthy, and I had friends who supported me during the turmoil. I preserved what I'd built not because of greed or control, but because I understood early on that self-protection isn't selfish, it's crucial. The prenup wasn't about mistrusting Cassandra upon marriage, but rather about realizing the importance of self-preservation. It was a realization that individuals and situations evolve, often leading to an unfamiliar person emerging from a once-promised forever bond. This understanding cost him $47,000 in legal fees safeguarding the prenuptial agreement, while Cassandra invested $198,000 attempting to nullify it. In the final analysis, we both obtained exactly as the contract had promised. However, he had accepted its terms initially, whereas she depleted her resources trying to alter it.